Welcome to the State of Ohio's Sexual Harassment Awareness Training presented by the Ohio Department of Administrative Services, Equal Opportunity, and Human Resources Divisions. Trainings of this nature are important to ensure the State of Ohio remains a diverse, inclusive, and equal opportunity employer that promotes safe and discrimination-free work environments. This training will focus on 3 key learning objectives. During this training, you will learn the difference between sex or gender discrimination and sexual harassment, and how both relate to broader equal employment opportunity law and policy. The important concepts of sexual harassment in the workplace, and learn what to do if you believe you are being harassed, and how to file an internal complaint and external charge if you have been a victim of sexual harassment or retaliation. It is important to have a basic understanding of the laws and policies prohibiting employment discrimination, including harassment. In this section, you will learn the basic legal policy requirements the State of Ohio must follow as an equal opportunity employer. You will also learn the difference between sex discrimination and sexual harassment, and how both relate to broader EEO law and policy. There are several federal and state laws and regulations which prohibit employment discrimination. The federal laws and regulations are Title VII of the Civil Rights Act of 1964, as amended in 1991. Age Discrimination and Employment Act, ADEA of 1967. Americans with Disabilities Act, ADA of 1990. Title II of the Genetic Information and Non-Discrimination Act, GINA, of 2008. The state laws and regulations are Ohio Revised Code 4112.02, Ohio Administrative Code 123, 1-49, Gubernatorial Executive Order 2011-05K, establishing an anti-discrimination policy in state government employment. These laws and regulations prohibit employment discrimination in state government. Under these laws, the State of Ohio is an equal employment opportunity employer. Your agency will also adopt anti-discrimination policies and procedures that you should read and follow. Equal Employment Opportunity, EEO, is the assurance that all employment-related decisions are based on objective, non-discriminatory criteria. State and federal laws and regulations require any state agency with 15 or more employees who work at least 20 calendar weeks to comply with EEO regulations. These regulations prohibit employment discrimination based on protected class, which includes race, color, sex, including sexual harassment, sexual orientation, religion, national origin, age, 40 or older, disability, physical and mental, military status, veteran status, or genetic information. So, what is employment discrimination? Discrimination is defined in civil rights law as unfavorable or unfair treatment of a person because they are a member of a protected class. It is discrimination to harass an employee due to their protected status, to include denying a reasonable workplace accommodation request because of religion or disability, and to retaliate against an employee for opposing discriminatory practices or participating in the EEO process. Sex discrimination is a type of employment discrimination. Sex discrimination is defined as treating a person unfavorably or unfairly because of their sex. Sex discrimination includes pregnancy discrimination and sexual harassment. Pregnancy discrimination involves treating a woman who is an applicant or employee unfavorably because of pregnancy, childbirth, or a medical condition related to pregnancy or childbirth. If a woman is temporarily unable to perform her job due to a medical condition related to pregnancy or childbirth, the employer must treat her in the same way as it treats any other temporarily disabled employee. Keep in mind, an employment policy or practice that applies to everyone regardless of sex can be illegal if it has a negative impact on the employment of people of a certain sex and is not job-related or necessary to the operation of the business. Harassment is a form of employment discrimination that violates EEO laws and regulations. Harassment is defined as unwelcome conduct that is based on a person being a member of a protected class. Harassment becomes unlawful when 1. Enduring the offensive conduct becomes a condition of continued employment, or 2. The conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. Petty slights, annoyances, and isolated incidents, unless extremely serious, will not rise to the level of illegality. To be unlawful, the conduct must create a work environment that is intimidating, hostile, or offensive to a reasonable person. Offensive conduct may include, but is not limited to, offensive jokes, slurs, epithets, name-calling, physical assaults or threats, intimidation, ridicule or mockery, insults or put-downs, offensive objects or pictures, and interference with work performance. Harassment can occur in a variety of circumstances. The harasser can be the victim's supervisor, a supervisor in another area, or a coworker. The victim does not have to be the person harassed, but can be anyone affected by the offensive conduct. Unlawful harassment does not require monetary loss or termination of employment to be considered harassment. Employees are encouraged to inform the harasser directly that the conduct is unwelcome and must stop. Also, employees should report harassment to management at an early stage to prevent its escalation. The employer may be liable for harassment by a supervisor that results in a negative employment action such as termination, failure to promote or hire, and loss of wages. If the supervisor's harassment results in a hostile work environment, the employer can avoid liability only if it can prove that 1. It reasonably tried to prevent and promptly correct the harassing behavior, and 2. The employee unreasonably failed to take advantage of any preventive or corrective opportunities provided by the employer. The employer may also be liable for harassment by employees if it knew or should have known about the harassment and failed to take prompt and appropriate corrective action. Retaliation is defined as taking an adverse employment action against an employee because they engage in a protected activity. This means that an employer may not terminate, demote, harass, or otherwise retaliate against you for filing a charge of discrimination, participating in a discrimination proceeding, or otherwise opposing discrimination. A protected activity is any activity where you have asserted your rights to or are participating in an EEO process. For example, filing or being a witness in an EEO charge, complaint, investigation, or lawsuit. Communicating with a supervisor or manager about employment discrimination, including harassment. Answering questions during an employer investigation of alleged harassment. Refusing to follow orders that would result in discrimination. Resisting sexual advances or intervening to protect others. Requesting accommodation of a disability or for a religious practice. Remember, when you participate in the EEO process, you have a right to be free from retaliation. However, you may not be protected from discipline or termination. You may still be disciplined or terminated by the employer if the employer has other legal reasons for doing so. Now that you have learned the basic legal and policy requirements, let's look at specific concepts of sexual harassment in the workplace, including ways to identify it and what to do if you believe you are a victim. Here are a few things you may not know about sexual harassment. The victim as well as the harasser may be a woman or a man. The victim does not have to be of the opposite sex. The Society for Human Resource Management published an article in 2015 indicating that same-sex sexual harassment claims seem to be on the rise. Increasingly, more male employees are filing claims that they are being harassed by other men. The victim can be a bystander or third party, and the harasser can be the victim's supervisor, a supervisor in another area, or a coworker. It is unlawful to harass a person because of that person's sex or gender. This type of harassment can include sexual harassment or unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature. Harassment does not always have to be of a sexual nature. It can also include offensive remarks about a person's sex or gender. In an employment setting, the conduct is made either explicitly or implicitly, a term or condition of employment. In other words, it interferes with the work environment through direct work action or indirectly through the general environment. Because we have a variety of social exchanges between employees, the distinction between invited, uninvited but welcome, offensive but tolerated, and flatly rejected sexual advances may be difficult to discern. But this distinction is essential because sexual conduct becomes unlawful only when it is unwelcome. Unwelcomed means the employee did not solicit or incite the conduct, and that the employee regarded the conduct as undesirable or offensive. A very important key to a harassment case is that the victim should directly or indirectly inform the harasser that the conduct is unwelcomed. This could be done through face-to-face communication, email, or reports through a supervisor. Although the law doesn't prohibit simple teasing, offhand comments, or isolated incidents that are not very serious, harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in an adverse employment decision, such as the victim being terminated or demoted. The reasonable person standard is a legal term used in harassment cases to determine if the harassing behaviors are severe or pervasive, or if there is a hostile work environment. When determining if harassing behaviors are severe or pervasive, or if there is a hostile work environment, the fact finder will ask, would a reasonable person find this behavior to be severe or pervasive? Or would a reasonable person, given these circumstances, find this to be a hostile work environment? The reasonable person standard has two purposes. First, the reasonable person standard protects us from people who are hypersensitive. For example, a person may be legitimately offended by a coworker asking them out to lunch once. However, a reasonable person would likely not be offended by such a casual request. Therefore, under the reasonable person standard, this behavior would not be found to be severe or pervasive. Second, the reasonable person standard protects us from work environments that have become so toxic for so long that the people working in that environment are desensitized and therefore are not bothered by inappropriate conduct. For example, if a woman begins working in a department that was previously composed entirely of men, and the woman complains about the inappropriate photos and joking as part of the general work culture, the fact finder would not ask if those particular employees find it to be hostile. Instead, the question would be, would a reasonable person from outside of this workplace walk in and believe that it is a hostile environment? This is because the employees who have been in that work environment have become desensitized to it, and therefore don't see any problems with their behavior. By applying a reasonable person standard, we protect ourselves both from hypersensitive people and from people who have become desensitized to inappropriate behavior. Another important concept to understand in a sexual harassment case is the difference between the intent of the harasser and the impact to the victim. In harassment cases, it is the impact of the behavior, not the intent of the person doing the conduct, that determines whether sexual harassment occurred. According to the law, actual intent is irrelevant. If an individual believes that behaviors are unwelcome, simply stating "that's not how I meant it," even though it might be true, is not enough to refute a sexual harassment allegation. To be clear, whether a specific behavior is unwelcome is decided by the victim or receiver of the behavior, not the initiator. Another note on intent concerns who the intended audience for the conduct may be. Just because the conduct was not directed or intended for the person claiming to be a victim doesn't mean harassment did not occur. In other words, a bystander or witness may have a claim of harassment, even if the conduct or statements were not directed at them. But do remember, a bystander or witnesses would still need to inform the harasser the conduct was unwanted before filing a claim. Under the law, the impact of the conduct is what is measured, not the intent behind it. Now that we have reviewed general concepts of sexual harassment, let's examine two types of sexual harassment: quid pro quo and hostile work environment. Quid pro quo is a Latin term meaning this for that, and occurs when an employer demands sexual favors in exchange for specified employment conditions. When submission to unwelcome conduct becomes the basis or condition of employment, the employer may be liable for harassment. A hostile work environment exists when a culture of harassment becomes acceptable in the workplace. Unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitute a hostile environment when the conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. Even though these two types of harassment are different, they are closely related. A hostile work environment may be created when a superior uses quid pro quo to force the victim to participate in sexual conduct, and that impacts the work environment or work performance. Further, if an employee or group of employees is consistently exposed to unwelcome conduct by a coworker or supervisor over time, it may become pervasive enough to create a hostile work environment. In examining sexual harassment cases, sometimes the hardest part is identifying behaviors that could constitute harassment. The EEOC has categorized harassing behavior into 4 groups: verbal, physical, nonverbal, and visual. Verbal harassment. Verbal harassment occurs when employees engage in any of the following behaviors: using terms of endearment, slurs, asking for sexual favors, inappropriate jokes, name-calling, insults, spreading rumors, innuendos. Physical harassment. Physical harassment occurs when employees engage in any of the following activities: blocking, close standing, touching, groping, grabbing, hugging, kissing, sex, rape. Nonverbal harassment. Nonverbal harassment occurs when employees engage in any of the following activities: staring, leering, following, stalking, written communication, gestures, inappropriate self-touching. Visual harassment. Visual harassment occurs when employees engage in any of the following actions: displaying offensive pictures, drawings, screensavers, and emails in public view. Remember, conduct is severe or pervasive, not both. Impact, not intent, matters. It is based on the reasonable person standard. Conduct must be unwelcome. Under the State of Ohio policy, your agency as an equal opportunity employer has a responsibility to keep the work environment free from harassment and discrimination. In doing so, your agency should do the following. Create a clear, concise sexual harassment policy. State agencies should have a sexual harassment policy that defines sexual harassment and explicitly states sexual harassment is not tolerated, explains the consequences, and sets forth a process for reporting and investigating complaints. Train employees about sexual harassment. It is recommended that employees receive sexual harassment training once per year, focusing on common situations that some employees might not consider to be sexual harassment, but are. The manager should also be trained on his/her added responsibility and duties to keep the work environment free from harassment. Monitor the workplace. The manager should make it a regular practice to talk to employees and ask them about the working environment. Establishing a clear and open line of communication helps to maintain the message that the state of Ohio stays harassment-free. Encourage employees to come forward. Agencies should adopt a reporting process that maintains as much confidentiality as possible. Creating a safe culture where employees know they can come forward is key to eliminating harassment. Take complaints seriously and investigate. Agencies should take all complaints seriously. If a matter arises to a formal complaint, the agency should perform a thorough investigation. If the complaint has any basis, the agency should take quick and immediate action. Now that you understand concepts and types of sexual harassment and what responsibility your agency has to you, let's review what you should do if you believe you are a victim of harassment. First, speak up. For a harassment case to be successful, the harasser must know the conduct is unwelcome. If you feel safe, say something. In many sexual harassment cases, especially those involving a hostile work environment, the alleged harasser may not realize that their conduct is offensive. In many cases, this will resolve the problem. If the issue isn't resolved, you have at least put the harasser on notice that you find his or her conduct offensive. Second, if the conduct continues, start documenting. Send an email to the alleged harasser and copy your personal email indicating that the situation was unwelcomed. Sometimes talking to the alleged harasser is difficult or the timing is not right at the time of the incident. But if you clearly let the alleged harasser know that the actions are unwelcomed, you have fulfilled your obligation. Document your own work and communications in case the alleged harasser starts to question your work performance to justify his or her behavior. When you document, be sure to make note of the time, who was involved, what was said, the impact to you, and any outcome because of the conduct. Third, you can talk to your direct manager, EEO officer, Human Resources Administrator, or DAS EOD. What if the offensive conduct doesn't stop, or the harasser tells you he or she doesn't care what you say or put in an email? All members of the management team have the responsibility for addressing all harassment issues brought to their attention. Even if the manager is not your direct supervisor, they have the responsibility for addressing any issues that come to their attention. After you speak to a manager, document your conversation immediately. Fourth, remember to follow your agency's policies and procedures. Every agency is required to have policies and procedures for addressing harassment situations. If you have any questions about the procedures, contact your manager, HR administrator, or DAS EOD. Lastly, file a complaint. It is hoped that once the management team is involved, the issue can be resolved quickly. But if not, you have the option of filing a complaint. We will discuss how and where to file in the next section. If you need to file a sexual harassment complaint or a complaint based on discrimination or retaliation, we will review the process and requirements in this section. There are two types of discrimination and harassment complaints: internal or external. One type is not to the exclusion of another, and you may file simultaneously. Investigation and decisions are issued in both types of complaints. The difference is the deadlines for filing and the formality of the legal process. As a state employee, the instructions on how to file internally are provided in your agency's EEO policy, which is required by the Ohio Administrative Code. The DAS-EOD administers the discrimination complaint process, which is overseen by the state EEO coordinator with DAS-EOD and their staff. If you file with DAS-EOD, you must do so within 30 days from the last date of discrimination, harassment, or retaliation. As a person residing in Ohio and the United States, working for a covered employer, you also have the right to file a complaint externally. You can file with either the Ohio Civil Rights Commission, OCRC, or the United States Equal Employment Opportunity Commission, EEOC, or both. The difference between the OCRC and EEOC centers on court systems and filing deadlines. In some cases, filing with one will automatically file you with the other. To file a complaint with the OCRC, you must do so within 6 months from the last date of discrimination, harassment, or retaliation. To file with the EEOC, you must file within 300 days of the last date of discrimination, harassment, or retaliation. Let's begin with the State of Ohio discrimination complaint process. You may ask yourself, what is the benefit of filing with DAS-EOD? First, DAS-EOD can address your complaint faster, meaning you experience change faster. The filing time is 30 days from the date of the last instance of discrimination, harassment, or retaliation. Once assigned, an investigation is usually done within 60 days as required by OAC. This means we can address the issue closer to the time it occurred, which is better for you and better for the work environment. Second, filing internally allows the state to utilize a holistic approach to promoting a work culture free from discrimination and harassment. We just don't investigate. We have an interest in promoting diverse, inclusive, and equal work environment for everyone. Filing internally allows DAS-EOD to work with agencies to not only help you, their employee, but to assist them in identifying broader work culture negative patterns. Together, we can find solutions for improvement, which impacts all employees at your agency. Third, as state employees, we are invested in you. Our goal is to create and maintain work environments free from discrimination and harassment. We want you to be a productive and engaged employee. By filing internally, this gives us the opportunity to be proactive in how we address issues. Remember, filing internally does not prohibit you from filing with the OCRC or EEOC or both. If you decide to file internally, it is important for you to understand your rights during the process. As the person filing, you are called the complainant. As a complainant, you are entitled to be accompanied, represented, or advised by any representative of your choosing. Request an external investigator be assigned to your case if you believe a conflict of interest exists with having your agency EEO officer assigned. Receive notice of your right to file the same complaint with the OCRC or EEOC, how to file, and filing deadlines. The first step to filing with DAS-EOD is to ask yourself a few questions. First, who are you? At the time of the incident, you must be an employee or applicant for employment to the state of Ohio. Second, what happened? You need to know what type of case you are filing: discrimination, harassment, or retaliation. You may file in just one category, or as many as you believe are implicated by the facts. Remember, cases must involve an employment-related decision or, for harassment, impact the work environment. Third, what protected status was involved? One of the protected statuses must be implicated in your allegation, meaning the accused has acted because you are of a certain race, gender, religion, etc. For sexual harassment cases, gender or sex are the most commonly selected statuses. Fourth, when did it happen? Did the last incident happen within 30 days of the complaint being filed? For harassment cases, even if the issues have been going on for a long period of time or is pervasive, the last incident must have occurred within 30 days from the date you file. If you are unsure of one or more answers to these questions, you can take advantage of a counseling session with either your agency EEO officer or a DAS EOD program officer. During the counseling session, you will receive information and resources about types of complaints, the process for filing, and assistance in answering your questions. Ultimately, the decision to file a complaint is yours. When you are ready to file your complaint, you can do so through either the myohio.gov portal or the Ohio DAS webpage. If you do not have access to a computer, you can also go to your agency EEO officer or call DAS EOD to have someone complete the online form for you. Some agencies have a policy where paper complaint forms are used. What you may not know is that information from those forms are entered into the system by your agency EEO officer for you. To file a complaint through the myohio.gov portal, go to myohio.gov, enter your State of Ohio employee ID and password. Scroll down the page to find hot links in the lower right-hand corner of the page. Click on File a Discrimination Complaint link. After clicking, you will be directed to the Discrimination Complaint Management page. This page contains information reviewed in this training and instructions on how to file. Please read through everything. If you have questions, visit your agency EEO officer or call DAS EOD. When you are ready, click on the hyperlink under Steps to File an Internal Complaint of Discrimination, which is near the end of the page. The link will take you to the online complaint form, which is directly connected to the State of Ohio Internal Discrimination Complaint System. To file a complaint through the DAS website, go to the DAS website at das.ohio.gov. Select the File a Discrimination Complaint link under Hot Links in the bottom left of the page. After clicking, you will be directed to the Discrimination Complaint Management page. When you are ready, click on the hyperlink under Steps to File an Internal Complaint of Discrimination, which is near the end of the page. The link will take you to the online complaint form, which is directly connected to the State of Ohio Internal Discrimination Complaint System. Now what happens? Once a complaint is submitted, DAS EOD will review it to make sure it has jurisdiction over your case. If it does not, you will receive a notice of reject and information on how to file with OCRC or EEOC. If it is accepted, you will receive notice that it has been assigned for investigation. Once assigned for investigation, the investigator has 60 days to conduct a thorough review of the circumstances. This review will include speaking to you, talking to witnesses, looking at documents, and reviewing other relevant information. If the investigator needs additional time, they may request an extension. You will be notified if an extension is granted. Once the investigator has completed the investigation, the agency will issue a finding. A finding means the agency has determined if probable cause exists to find discrimination, harassment, or retaliation has occurred in your case. Once the agency has made its finding, it will inform you of the determination and how to appeal. If you disagree with the agency's finding, you can appeal to DAS EOD within 15 days. You can either write DAS EOD a letter or send an email to the contact listed in your appeal letter. Once DAS EOD receives your appeal, it will decide on whether to accept or deny it. If the appeal is denied, you will receive notice and information on how to file with OCRC or EEOC. If it is accepted, DAS EOD can take one of three actions: remand the matter back to the agency for a supplemental investigation, order the agency to take corrective action consistent with EEO law or policy, or order the matter to a hearing. Remember, at any time you may file a charge of discrimination, harassment, or retaliation with the OCRC or EEOC. Let's briefly review the requirements and ways to file with the Ohio Civil Rights Commission. The Ohio Civil Rights Commission has jurisdiction to investigate charges of discrimination in the areas of employment, housing, public accommodation, disability in higher education, and credit. All charges of discrimination must be filed within 6 months of the date the discrimination occurred. You can file a charge with OCRC in one of 3 ways. You may visit one of the 6 office locations to file the charge in person. You may file by U.S. mail. You may complete the charge form online and submit it directly from the OCRC website. Did you know that for certain types of cases, there may be dual filing between OCRC and EEOC? This means that by filing with one, you are filing with the other. To learn more about dual filing, visit eeoc.gov. More information on filing a complaint with the OCRC can be found at their website, which is included in the additional resources at the conclusion of this training. You may also choose to file with the EEOC. The EEOC enforces federal laws prohibiting employment discrimination. To file a charge with EEOC, you need to meet the following requirements. The claim must be one of employment discrimination, harassment, retaliation. You must work or apply for a job with a covered employer. The state of Ohio is a covered employer. You must be a member of a protected class. You must file the charge within 300 days from the last incident of discrimination, harassment, retaliation. There are several ways to file a charge with EEOC. A charge of discrimination can be completed through the EEOC's online system, in person at an EEOC office, or you can file a charge by sending EEOC a letter. More information on filing a complaint with the EEOC can be found at their website, which is included in the additional resources at the conclusion of this training. If you have questions about the content of this training or other questions on employment discrimination, harassment, or retaliation, please contact the Ohio Department of Administrative Services, Equal Opportunity Division, Affirmative Action Equal Employment Opportunity Unit, by phone at 614-466-8380 or by email at das-eod.aaeeo@das.ohio.gov. Thank you for participating in this training and supporting the state of Ohio in fulfilling its mission to remain a diverse, inclusive, and equal opportunity employer.